What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Friday. We had a hearing for Donna Adelson earlier today. The audio on that was not great. So I just re uploaded the full hearing where I tweaked the audio to where it's a lot easier to hear. So you can go back and watch that if you would like. But I am going to summarize the hearing today. If you're not following me here on YouTube or social media. So I'm going to take a little time off before her trial. My daughter's moving tomorrow to New Orleans, which is incredibly emotional. And me and my youngest are really having a hard time with it. So at the very last minute, I decided we would go to Disney World with Fruit Loop, Brienne, and her kids like we had planned to do before my daughter decided to move. So we are heading out very early in the morning. I think it'll help us not to be sad and down all weekend because if I were sitting here at home, I would be a hot mess. Just that first kid leaving the nest, it's not easy. And my kids are just an extension of me. So I feel like part of me is being ripped away, but it's the circle of life, doesn't make it easier. Not going to do a music fact or anything like that today. Don't pass out, but I got packing to do. You know to subscribe. The best thing you can do is like the video. That helps push it out to other people who may not know I'm around. Share it with your friends and then hit that bell if you want notifications. Just a little note before we do jump in the hearing, there was a filing yesterday that was sealed, but the title of that, it was Donna Adelson's sealed motion in limine concerning the testimony of Robert Adelson. Robert being her estranged son, the normal Adelson who is off living his best life away from all this drama. Also, the motion to dismiss the indictment was denied. And I think you guys know that the trial will be held in that bigger courtroom. I haven't seen any more rulings on the outstanding motions, but we will cover those before trial starts. You may know about them before I do. I will be posting some videos from Disney, by the way, so keep your eye peeled for that. When her defense attorney Rashbaum gets started, he said that pretty much everything is in the filings. So he's just going to summarize the main points. This is surrounding Sergeant Corbitt's PowerPoint he intends to introduce. If you remember, it's very lengthy, I believe maybe 300 plus pages. They say they're not asking that he not be allowed to testify. What he's testifying to doesn't meet the qualification of Florida statute or the qualifications of an expert witness. He is a summary witness. The report that he's bringing in has different components, including emails, text messages, video surveillance, photos, and call record summaries. And it takes no expertise to do that. Cell site data, especially in regards to Donna. The defense says there's more with Sigfredo and Rivera, and that didn't qualify as expert testimony to bring that in. And there's virtually nothing from Donna in that regard. The report could be used as a demonstrative aid. And for example, an email between Wendi and Donna is admissible. It could be brought in through an appropriate witness, such as Wendi herself. But the summary of the 1 or 2 page email in the exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. The judge says that makes sense. And the one question he has for demonstrative purposes, can the state put context around it? The defense goes on to say that Sergeant Corbitt is allowed to be a witness, and our argument is he is not an expert, and this exhibit should not go back to the jury. He says his argument is supported by Florida law, and the Florida Supreme Court says law enforcement testimony summarizing cell phone location data is not expert testimony because it doesn't require a specific skill. The sergeant has no expertise to say what cell tower was used, not able to look up the longitude and latitude to mark intersections. And that's on point with what he says the witness is going to be doing here. He pulled data off of iCloud and iPhones, and that's not expert testimony, but he can testify to it. The judge says the data pull itself is a factual issue. How the machine works and whether or not that pull took place in a correct manner, that goes to more specialized information. He said if it's going to be contested, the data wasn't pulled correctly, we would get into a situation dealing with specialized information, knowledge, and expertise. But you hear the state whisper to the defense, you stipulated to this. So the defense tells the judge they don't believe it's going to be an issue, but if it does, it would be subject to his qualifications, meaning the witness, which they think he has. He has those qualifications. And the defense says, as far as if it was pulled appropriately, we are not contesting that. He goes on to say the second part of the argument is not dependent on the first part. Whatever turns into his demonstrative exhibit and whether it goes to the jury as a whole, this is a summary. It's not a neutral summary. And when you look at the summaries, it's full of items like 30 to 40 emails. Summaries are done for taking many records and just making that easier for the jury. In this document, you see a bunch of items that aren't huge, 1 to 2 page emails, 1 page of text messages, call records, and then call summaries. Again, says the evidence in it is admissible and can be admitted, but the exhibit itself is only to be used as demonstrative. He said they do see some things that are problematic. The judge says they'll address that at the hearing next Thursday. Now, the state gets up and says the defense says you don't have to be an expert to testify to phone evidence. The defense cited the King and Gordon cases in their motion that was submitted. And in both of those cases, which are post conviction motions, it was ruled the defense was not ineffective for not getting their own expert nor not objecting to the witness testifying for not being an expert. The defense in that case did not object to a non expert law enforcement officer testifying to the cell phone evidence in that case. She goes on to say it was a strategic decision where the defense knew he could cross the officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected in the Gordon case. The witness from the phone company would have qualified as an expert and testified to the cell phone data had there been an objection. In the other case, King, they put an expert on the stand to testify about cell phone data who said the defendant could have been home and not at the crime scene at the time of the murder. So in that case, there was an expert that testified. The judge asked the state, what exactly is he going to testify to beyond what the cell phone data records or tower records would show that would otherwise need him to testify through an opinion, but he can't testify off the records themselves? The state says he's not testifying to everything in the summary, but as an expert on the cell site location data, as far as who is using the handset at the time and how far they are away from the cell tower. The judge asked as far as how to interpret that data, and the state says yes. The state goes on to say he uses more than just cell records to do that. But in the cases Gordon and King that the defense cited, it says a witness doesn't have to be an expert to testify to some of that information, but they're not saying you cannot present an expert to offer an opinion on a handset's location if that witness has the necessary training and expertise, just as it was done in the hearing in the King case and could have been done in the Gordon case. Sgt Corbitt has hundreds of hours of experience and training and has offered expert opinion in well over 100 cases in circuit court. This is him forming an opinion on how far the handset is from a location, who may be using the handset at the time, and it's beneficial for the jury to hear this to interpret the information. The defense comes back and says there's too much in this summary. The purpose is to summarize the evidence. There's a large part of the presentation, such as videos from the gym Dan was at, a traffic ticket that Sigfredo and Rivera got, the car rental agreement, and it's not a lot individually, but the witness is using all of this to show who had the handset at the time. And if a suspect's cell records are consistent with a car rental company, an expert may be able to better determine who was using the phone at that time and confirm their location and the reliability of the cell site information. The defense says that this exhibit is a closing argument. There's a lot of digital evidence that's all encompassing. What's in the presentation? It's all data, business records, cell records, emails, and text. The state says when I'm handing over what I'm using in my presentation, I'm trying to be thorough. I don't intend to use all 30 or 40 emails or have Sergeant Corbitt read them all. I want to say these were on the accounts. And did law enforcement find some sort of motive that made them look into these people? The judge asked for what you'd ask Sergeant Corbitt to add to this. Is this, in fact, his opinion? The state says it's his job to pull information from these devices and interpret the data. He has to rely on the investigators to let him know what they're looking for. Sergeant Corbett is going to see if there's a needle in a haystack. He would let the investigators know if there is. I ask the questions, he looks for answers and lets me know what the data says. I say that's important, so put it in there. If a witness says something happened, I can ask Sergeant Corbett, did this happen? And he lets me know if it corroborates what the witness says. And if so, we put it in. And he can give an opinion about where the cell phone was and how close they were to the tower, things that I couldn't see or know on my own. The defense says that summaries are not admissible, and the state says, I don't know of any law that says it's not. If they have an objection to certain slides, we can discuss, but there's no case law I could find saying that, and the defense didn't cite any either. The judge says if you take thousands of pages and you break that down into something that's digestible for the jury to use in making their decision, some of these things are more or less part of the state summary that shows corroboration of other evidence is in fact a summary as the statute defines a summary. The state says the things that may corroborate other evidence, it helps this expert form his opinion. For example, with the car rental records, he can say they were this far from the tower. Now, as far as who's talking, it's all that other evidence that helps him form his opinion. The defense says we aren't arguing that summaries aren't admissible. We're arguing this doesn't meet Florida statute as a proper summary. There's one really large document they're summarizing, and that's how they got originally to Harvey Adelson's phone number, where they had data that would go to the ceiling. If they wanted to do a summary exhibit on that piece, it might be allowed, but everything else is a closing argument. We may as well say when you do your closing argument, that should go back with the jury too. And defense says that's all I have to say. The judge said he would rule in part Sergeant Corbett can be properly qualified as an expert witness because the judge finds he can testify on the interpretation that goes beyond where the towers are, what was pinging, and what the records show. That would be scientific, therefore, he's qualified. As far as the summary, the judge wants to hear more from Sergeant Corbett. So he's going to have Sergeant Corbett testify after the hearing next week, which is Thursday at 9 a.m. Eastern, by the way. There was also a defense motion in limine concerning testimony from Wendi about her book and changing the names of the children. The judge said he would allow the state to use this as impeachment dependent on the testimony given by Wendi. The state intends to use the jailhouse recordings, but not admit the ones that feature Charlie. The prosecutor asked about the changing of the names, and the judge says, based on prior testimony that Wendi has given, they can ask about that. The defense says their motion was to prevent the state from inquiring about the name changes. They can't ask, did you change your kids' names? That was our motion. He says, I'm not sure of the ruling. Can they ask that question? The judge asks, what is the point? And the state says motive. And the judge says he will permit it. And also for impeachment, depending on what comes out at trial. Motive is available for both parties to explore. He moves on to that motion in limine where they ask that they not name the Latin King specifically because Donna essentially is saying she was threatened by a Latin King gang member. And the judge says that this is going to, in some way, create a greater credibility in front of the jury for whatever narrative the defense wishes to weave. He said, I will permit Donna if she testifies she acted in accordance to being threatened by a gang member. I don't think naming the Latin Kings is going to assist them assessing her story, whether it's credible or not. They'll make their determination if they believe this testimony. As to ruling about Jeff Lacasse and what he can and can't testify to, The judge says he has not finished his research, but he will rule before jury selection begins. The state then talks about when will we have our first witnesses. She says, can we all agree we will not start until Friday, assuming we have a jury by that Thursday? The judge and the defense both agree that's appropriate. Openings can start Thursday afternoon if they have a jury, and the state thinks their case in chief will last 6 to 7 days. The defense says two. At this point, the judge addresses Donna and says next week is the final pretrial and will address plea offers. If you wish to consider a plea offer, the time is rapidly coming for you to decide if you want to entertain that. If you want your counsel to present an offer to the state, the time is coming. Once we begin jury selection, trial has started. And because of count one, my hands are tied concerning any sentence on that. If you are considering anything, you need to make a decision on this quickly. And that was the end of the hearing. So, lots of things going on. Donna, her trial is rapidly approaching. It's go time. She looks a bit stressed to me personally. Things didn't go so well for her boy Charlie, and now it's her turn. So we will see what happens. But the next thing, of course, that hearing and next Thursday, 9 a.m., I will be traveling back to South Carolina from Florida. So go watch that on Law and Crime Network because I won't be streaming it, but I will put up a cleaned up version of the audio if it's bad when I get home and settled. And unless I throw out some wiretaps here or there, I will see you guys on September 17th, the first day of jury selection for Donna Adelson's trial. That's it. Hope you guys have a good week and a half or so. We'll see you soon.